Welcome to Employee Benefit Plans and Business Sense.
Hey everybody, welcome back to an all-new episode of Employee Benefit Plans and Business Sense with Lank and Kathleen Salas-Bass. I'm your host, Mike Leon. You know, Dal and Kathleen have been helping employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. They've got decades of combined experience in employee benefits law, and they help clients and referral partners avoid costly mistakes and resolve issues before they become legal problems. That's a huge thing. You know, in today's episode, we're going to be talking about what corporate attorneys should know about benefit law and why it's important for their clients. So, Don, let me start with you, and good to see you ladies both. So why is it so important for corporate attorneys to understand benefit law?
No, thank you, Mike. The corporate attorney is usually the first contact with the law for the client. So, let's say an employer sponsors employee benefits plans, including retirement plans, health and welfare benefits such as medical insurance plans, etc. They sponsor these plans for their employees. They interact with the corporate attorney much more frequently than they would necessarily interact with a benefits counsel, unless they have in-house benefits counsel. And so an in-house attorney or a corporate attorney, an outside corporate counsel, is really the first legal issue spotter for the company. And they should be aware, corporate attorneys should be aware of the benefits issues so that they can spot them for their clients.
And Kathleen, anything to add on that?
No, I think, that is, corporate attorneys are often the ones who are doing like the mergers and acquisitions aspects. And as Dahl said, they're often the attorneys that the clients go to when they have an issue, just because that is sort of an ongoing, place where the employer and the law sort of their legal counsel meet.
Right, that middle ground right there. So Dahl, let me ask you, for attorneys who don't practice in this area, what does benefit law actually cover?
So employee benefits means the retirement savings plans that are qualified under Section 401A of the Internal Revenue Code for various tax benefits. And these would include the classic 401K plan, profit sharing plans, defined benefit plans such as a traditional pension, and also the health and welfare benefits that an employer might sponsor, such as a medical insurance plan, Blue Cross Blue Shield, United Healthcare, et cetera. These kinds of insurance programs, if they're offered through an employer, they'll be subject to all the different rules that apply to employee benefit plans and other not just fringe benefits, but other welfare plans such as disability insurance plans, for example, would fall under the purview of any employee benefit. So, if a company opens its employee handbook, if it has an employee handbook and it provides and sort of boasts of its employee benefits, that list of benefits, many of them are subject to these qualification rules that I mentioned, and also to ERISA, which is the overarching federal law that applies to employee benefit plans for private employers.
You know, what benefit problems do you most uncover, both of you, during this review process of these corporate transactions or even these M&A type of deals? What are some benefit problems that you most often uncover?
Well, I think that a very common one is not having ERISA compliance fully in place for the health and welfare benefits. Kathleen can speak to that a little bit in more detail because she's our health and welfare expert in our firm. But there's a requirement that there be much more documentation than there usually is for medical insurance plans. And there's often the biggest overall problem that we find in an M&A deal is just not preparing for the benefits issues well enough in advance. It's important not to rush through, or it's sort of impossible to rush through proper due diligence for benefit plans. And if it's left to the 11th hour, which happens often, it can be a real scramble, a real scrum, I guess is what I'm saying, to get the benefits really vetted understood so that the representations and warranties are accurate and limited if possible. If you're representing the seller, for example, if we're representing the seller, we like to make sure we're not over-promising anything in the representations and warranties in the deal, and that any compliance issues can be handled with some sanity instead of being rushed through at the end.
Yeah. And Kathleen, you were mentioned, and by the way, we should also explain the acronyms like M&A, mergers and acquisitions. But Kathleen, take us through a little bit of ERISA, what was just mentioned there.
Well, I mean, I think just to add on to all the good information that Dahl just mentioned, I would just say that, health and welfare plans are often run through an insurance broker or someone, and the employer depends on just the insurance contracts and the insurance prepared documents, and there really needs to be a wrap document. I have many stories about how representing a seller who didn't have a wrap document, and rather than having to disclose as part of the sales agreement that there's no wrap document, I would draft one, and get it taken care of. So that's, if we have enough time, to a certain extent, we can fix some of the problems rather than have to then disclose them and have them be a problem. Because a benefits issue should never be a problem that in an M&A deal. It should, always be something that can fix it. I think another important thing, a couple of things I would mention is dealing with what's going to happen to the retirement plan in an M&A transaction is vital, because unlike health and welfare benefits, which should be planned ahead, like what's going to happen with the employees, the new employees, maybe after there's an acquisition. Those things can be dealt with, even if it's kind of messy, if it's not done ahead of time. But the retirement plan side can be really, really problematic if the retirement plan is if there's two retirement plans involved, one on the buyer side, one on the seller side, then it can be really problematic if those plans are not compared, aren't looked at, because it may be that the buyer doesn't even want to take on a problematic plan, or they don't want a second plan. And if they don't negotiate so that the plan is terminated before the sale, then the buyer is stuck with two plans, one of which may have many problems that will have to be resolved and fixed before they can merge them. So it's one of those things where on the seller side, you want to do all this due diligence so you can make sure they can make those reps and warranties, or they can properly disclose any exceptions, or on the buyer side, they know what they're getting and they can make sure that appropriate actions are taken before the close of the sale to make the benefits transition much more seamless, much less problematic and expensive down the road.
I couldn't echo it more, Kathleen, as somebody who's worked for two companies that got acquired. And the first question I had was, hey, what about my 401k? Can I roll it over? Exactly. So it's timely material. So let me ask you then, before a full review even starts up, and Dal, this question is for you. What early signs might suggest to an attorney that a client's benefit plan, it needs a closer look?
Yeah, I'll answer, and I'll preface this by explaining the big acronym that I used earlier, which is ERISA. That is Employee Retirement Income Security Act of 1974. It's a very old law now, and it's basically it's a federal law, preempts state law, and governs employee benefit plans for private employers in the country that want to avail of all the different tax benefits of having a plan. In order to get those benefits, the ERISA needs to be complied with, and it's mostly about ensuring that all employees who are eligible are treated fairly under the plan. So with regard to the early signs that might suggest that sort of red flags in a deal, the first things that we look for are making sure that all of the benefits that are subject to the deal, all the benefits of the target company, are identified, and simply asking the question isn't always enough. If you ask the seller, "What are your employee benefits?" they might not know exactly what they are, and what is all covered by the term employee benefits. So if a company has an employee handbook, you get out the handbook and see what that is, see what's listed there. If it doesn't have a handbook, you just try to find out, what are different benefits that they offer to their employees, and you can usually finally get to that answer. And I think one of the red flags that I would see if in a deal is if there have never been any compliance filings for those plans, for example. That's a very superficial way to see the plan filings are called the annual Form 5500 filing, and for a ERISA plan, and the failure to file one that exists would be a compliance issue immediately. So we just start trying to fill in all the compliance tasks and make sure that they've all been completed. And if there's some gaps in that checklist, then we see that there's more work maybe needed to address it before the deal closes.
I want to piggyback on something you just said there, because I think there's obviously you explained the acronym, but then I think there's also the difference between there's employee benefits lawyer, there's the corporate attorney that's reviewing some of this stuff. So when a company's benefit plans are being reviewed before the sale or merger ends up happening, what's the difference between what an employee benefits lawyer can do versus what a corporate attorney usually can't do?
Oh, that's a really good question. The deal takes place 99% of the time under an agreement that's just a preliminary agreement that establishes confidentiality between the parties, and it's basically a letter of intent, or even a purchase and sale agreement might provide for an out if the due diligence period is results in something surprising, but the parties agree to disclose information to one another, and the corporate attorney is in charge of the deal, and there's usually a corporate attorney on each side, and they elicit all of the information that might be relevant to the pricing and timing and content of the sale or merger. So they're in charge of the entire company's assets and book, financial records, all their property, their intellectual property, their real property, everything else. And the benefits attorney is only working on a small segment of the entire deal, which is the benefits. So while the corporate attorney is working on all the huge scope of data and facts that go into the deal, the benefits attorney is looking at just the plans, the plan documents, what the communications with employees have, all of the financial record keeping of the plan and tax reporting. It's really informational reporting on this Form 5500. All of that is what we as a benefits attorney look at, but it's only a sliver of the entire deal. And it's often why it's overlooked in a deal, because there's a lot for the corporate attorney to do and deal with. And if they're not spotting the issues with benefits, they might easily neglect benefits before the deal closes. And having said that, the employee benefits can really change the value of the company, of the acquisition for the buyer, because they could be buying a lot of liability if they're not careful.
Right. This is why we explain these key differences and the acronyms as well. You just got me thinking, Kathleen, let me turn to you, because, and I'll ask you the same question as well, but have you guys seen a deal where catching this benefit plan problem early made a huge difference in how it turned out? Kind of piggybacking there on Dahl's example. Kathleen, I'll turn to you.
Yeah. Well, yeah. I mean, I think sort of similar to what I was talking about before, I worked on many deals where, the buyer was open to taking on the seller's plan. But once we did the due diligence and discovered some very, serious problems in their retirement plan that were going to require, some expensive corrections, then, that helped the buyer to say, no, I don't want to take this on. And so, they negotiated such that the seller terminated the plan before the close of the sale. And that plan sort of became an issue, that the seller had to sort of wrap up. And in the meantime, then the buyer didn't, got to keep their plan clean and squeaky clean, and be able to just sort of bring the new employees into their existing plan without having to take on the liability for all the corrections, that would have been expensive, that would have had to have been, you know, corrected before they could merge the plan into their existing plan. So.
Dal, same thing. Any specific examples you can think of that you want to give and share to our audience?
Well, I think the rush to correct or the opportunity to correct before closing is the main pivot that happens. Nobody expects it, or rarely does anyone come to us proactively announcing that they have a failure that they need to correct before they sell. Usually that's what the pivot is identifying a failure and hopefully in advance and quickly correcting it as much as possible. And so things like changing, the buyer pivoting now and saying, no, you need to terminate your plan, as Kathleen alluded to. You need to terminate your plan. We weren't going to do that, but now we are. That's what happens a lot. And then just the rush to correct happens a lot to make it feasible to close. And it's usually doable if you catch it.
Ladies, I'll ask you this question because we just mentioned them before about the difference between the corporate attorneys and the employee benefits attorneys. So how can, and Dal, I'll start with you, how can these corporate attorneys maybe make benefit plan reviews a part of their work? And what would you recommend would be maybe a best first step for them if they want to learn a little bit more about benefit law?
With a client, the best first step is to just know what the benefits are. And if they have the kind of relationship with a client where they're in touch with them regularly, well before a sale or well before an acquisition, they can ask and know and be aware of what the benefits are that they're offering their employees. The best practice for an employer of any size is to have a plan committee, and not just to help with regard to choosing investments for the plan, which is a whole other exposure to liability for retirement plans, but also to help with the administration of the plan. So a corporate attorney who has a continuing relationship with a client should have on their checklist, their annual checklist or whatever it is, to know what the employee benefits are. And does the employer have a plan committee? Is that committee meeting and functioning and dealing with plan issues? Because plans are ongoing. It's not just at the deal, at the moment of the deal. Now, if a corporate attorney who only does deals wants to learn more about employee benefit plans, or a corporate attorney who'd like to start incorporating this sort of routine practice of benefit hygiene with their clients, I would recommend reading our blog. We have a great blog on our website that has focuses on different aspects of retirement plans, and it's not a marketing blog. It's actually substantive. And we also have newsletters archived on our website, that a searchable archive of topics. And we do write for normal people to understand. It's not written for ERISA attorneys. It's written for plan providers, plan sponsors, attorneys in other areas of practice. So or any other blog. Just read on the internet about what are employee benefit issues. And I think that again, touching with the client, if you're facing a deal, a corporate attorney should be asking the client just right along in their checklist with, are there any skeletons in the closet financially, or any issues? Do you have debt? How are your employee relations? How are your client relationships? The kinds of things you're looking at when you're preparing for a deal. On the list should be benefits. How are what are your employee benefits? Are they functioning? Have you had any compliance issues? Do you have any questions about them? Just getting the client talking about the benefits will help the corporate attorney understand if there are any issues, for sure.
Kathleen, same to you.
Yeah, I just think that the best thing a corporate attorney can do in an M&A situation is to have it on their checklist to bring in employee benefits attorneys early on. And over the years that I've worked doing M&A work, we find that the corporate attorneys who learn this, and they regularly bring in an employee benefits attorney into a deal at the beginning of the deal. They learn the value of it, and this becomes a regular sort of thing. And so I think that would be my recommendation is to just, respect the employee benefits aspect, but also, make sure you find, your go-to employee benefits attorneys, who you would bring onto your team, understanding that, it's better to have us on the team in advance, to, go through any issues, rather than either not having an employee benefits attorney on the team ahead of time and either having, rushing through it at the very end, which doesn't accomplish a lot, or having to do the cleanup after the deal is closed. And that's always going to be more problematic for the client if they're going to have to deal with a lot of cleanup after the close.
Well, ladies, thank you so much for the time and insights on this subject. We truly appreciate it.
Thank you, Mike.
And thank you, everybody, to listening and watching this episode of Employee Benefit Plans and Business Sense. If you're a corporate attorney who wants to protect your clients and your deals from benefit plan surprises, do me a favor right now. Visit klblawgroup.com to connect with Dahl and Kathleen. Be sure to like, subscribe, leave us a review, and comment. Share this episode with someone you know that may need to listen to this type of advice. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.